Hello and welcome to another edition of IP Soundings. Joining me here today from Los Angeles, California is J.D. Harriman, a patent attorney and partner in the intellectual property group of Arent Fox. Welcome, J.D.
Thank you, David. Good to be here.
J.D., can you tell us a little bit about your practice?
I am a patent attorney specializing in patent prosecution, which is the obtaining of patents and patent portfolios for companies, as well as licensing, high-level counseling of compliance, litigation. I do participate in IP litigation support, and what are now called post-issuance or post-grant proceedings at the U.S. Patent Office.
Thank you for that. We'd like to kind of take this to some fundamentals here, especially for our companies and audience here who may be more in the emerging company market. So I'd like to get to some basics on patents. Can you tell us how difficult is it to actually obtain a patent?
That's a good question, and it's a question that most emerging companies want to know. Will I be able to get a patent? And the answer is almost always yes. The standard of novelty in the United States Patent Office is achievable. If you file for a patent application and it meets the statutory rules of a patent, you're likely going to be able to get some sort of coverage for your invention. The Patent Office is pretty reasonable on granting patents. It's kind of an unfair fight because the patent attorney has so much more time to spend on the patent application than the examiner does, but you will get a patent.
Well, with that as a backdrop, we're talking about patents, but there are rights to go with patents. Can you tell us a little bit about what those rights are?
Yeah, a lot of people think if you have a patent, that means you have the right to build your invention and sell your invention. In fact, that is not the case. In the United States, patent rights are known as negative rights. It means you only have the right to stop others from making, using, or selling your invention. For example, if someone had a patent on a chair and you, David, were to invent the rocking chair, you would be able to get a patent on your rocking chair because it is different from a plain chair. But you wouldn't be able to build your chair without getting a license from the owner of the patent for the basic chair. By the same token, the patent for the basic chair could not build a rocking chair because of your patents. So you would have to cooperate, cross-license each other in order to be able to build your product.
Wow, with that as a backdrop, what are some of the important issues that we're hearing about today in the area of patents?
The number one issue in patent law today are so-called patent trolls, or what are referred to as non-practicing entities. These are companies that acquire lots of patents. They do not build any products or manufacture any products. They simply collect patents and offer to license those patents to companies that do build things out of allegations of infringement. They will often settle out of court for some licensing fees, but often these patent trolls will take companies to court in order to force them to pay for the right to practice under these patent applications that they've acquired, patents and patent applications. It's a big problem for companies today. It's become an expense associated with doing business that didn't exist before. In the past, companies that made products would sue each other. That happened about 1,500 to 2,000 times a year in the U.S. That has kept up the same pace, but patent trolls now account for about 2,000 patent cases a year, so they have exceeded the number of lawsuits between regular companies just in this past year. So it's a meaningful problem. It's doubled the number of patent suits, and as you can imagine, it's increased the cost of doing business, because if you have to pay a patent troll for licensing for patents, it cuts out your profit, or you have to raise prices, or some combination of that. So that's been a big problem. But the Good news is there have been a lot of things that happened recently to help companies deal with the patent troll problem. One of the most important of these is the America Invents Act. It's a sweeping change to the patent laws that has been implemented over the last year and a half. And an important aspect of that are something I mentioned earlier, the post-issuance proceedings. There are now methods in the patent office where you can challenge the validity of a patent without doing it in court. An advantage of this is it's much faster and much cheaper. Typically, if a patent troll were to file a lawsuit against you, very early on you may look at the patents and say those patents are not valid or they don't apply to me. If you want to challenge the validity, you would go to the patent office and use one of these post-issuance proceedings. There's something called post-grant review, something called re-examination, and another approach called inter-partes review. They are relatively expensive, but much cheaper than litigation. The Patent Office has done their own estimates of the costs of doing these patent office procedures, and they're about 1/10 the cost of litigation. Now, we all know that government is not really good at estimating how much things will cost, but it'll probably be 3 to 4 times cheaper to litigate in the patent office than it will be to litigate in a court.
Thank you, JD. Those are terrific insights. We really appreciate the information that you've shared. And I want to thank you for joining us here at IP Soundings.